Does it matter who files first? Usually not. I get that question a lot. People come into my office to file for divorce, and one of the first questions is, should I file first or should we wait for the other party to file? Well, in most situations, it doesn't matter. If you don't have kids, not a lot of assets, it usually doesn't matter. However, if you have kids and the other parent is acting in a way that poses a danger to the kids, then you gain a distinct advantage by going first and filing first and getting to the judge first. Because a lot of times what I will do, and most attorneys will do in those situations, is we'll spell out all of the things that we believe that other parent is doing that puts the children in danger. We take that to the court. The court gives it to the judge. The judge looks at it. The judge reads it, reviews it, makes a decision right then and there as to whether or not there's enough proof in the complaint to warrant issuing an injunction. And in those cases where that happens, you gain a distinct advantage by filing first. If you're in jail, what happens to your child support? Well, until about a year ago in Tennessee, it kept growing. If you got sentenced to 3 years in jail and you were paying $500 a month in child support, that child support kept mounting up while you were in jail. So over that 3-year period, that could have been $18,000 in arrears you would have when you got out. Heck, I got guys in prison getting out that have $30,000, $40,000 in arrears that they owe. But the law changed May of 2020 in Tennessee. Now, if you're incarcerated, that can be a grounds to reduce or eliminate child support during the time period that you're incarcerated. So, if you go to jail in Tennessee, it's important that you file a motion or petition to modify the child support based on a change in circumstances and be able to show the court that you are in jail, how long you're in jail for, and to ask for a reduction or elimination of child support while you're incarcerated. Can you change your child's name? Well, the short answer is yes. You can change your child's name. You and the child's other parent can agree to change the child's name, take the child down to court, and have the child's name officially changed. But what if the other parent doesn't agree? Or what if you can't find the other parent? Well, you have to put the other parent on notice of the name change. And you do that in one of two ways. Number one, you serve the other parent with paperwork from the court stating that you want to change the child's name. Give that other parent an opportunity to come forward and to dispute that. Okay, that's number one. Or number two, you have to publish notice. If you truly don't know where the other parent lives, you can publish notice, and that serves as official notice to the other parent that you are wanting to change the child's name. And in either one of those circumstances, or by agreement of the other parent, you can change your child's name. So I got a call the other day from one of my clients. He's going through a divorce. And he and his wife, soon-to-be ex-wife, had sat down and come out with this elaborate agreement about child support. Neither one of them was going to pay the other one child support, okay? Mistake number one. Number two, he wanted a provision put in the parenting plan that said that the child support could never be increased, that it would always remain zero, and neither party could come in and increase the child support. Well, both of those provisions I could not put in the parenting plan because the court gets to determine what child support is based on the law and based on the fact that it is for the best interest of the child and not for the parents. The parents can't agree outside of the statute what child support is going to be because the child is not a party to that agreement and the court is there to protect the interest of the child. Therefore, such an agreement in a parenting plan would be void. I met Tom when he was 67 years old, a big guy. Well, what happened was when he was 60 years old, he met a girl in a bar and got her pregnant. And she was 35 years old. Now he's got a child. His child was 7 years old when he came in to see me. He's been paying $1,000 a month in child support since the child was born. He gets summers with the kid. The mom moved down to Florida with the kid, so he gets him in the summertime and some alternating holidays. He wanted to reduce his child support because he wanted to retire. He wanted to reduce it down to about $300 a month. I looked at him, I said, that's going to be a tough one. We went to court. The judge looked at him and said, no, you created this situation. You're still able to work at the same level you were. Just because you want to retire doesn't mean you get to. You're going to have to continue to pay child support at that $1,000 a month rate. When you are truly able to not work anymore or unable to work, then we can revisit this issue. But right now, you're still able to work. You got to do it to support your kid.